Where can a divorce case be filed in Virginia? Well, there are really two concerns when you're considering where you can file for divorce in Virginia. The first one is jurisdiction, which is the power of the court to decide the matter concerning the parties before the court. And the second one is venue, which is more a matter of convenience to the parties. Where should this case most appropriately be heard for the sake of everyone's convenience? As far as jurisdiction is concerned, the Virginia Circuit Courts are the courts that have original exclusive jurisdiction over divorce cases. So a divorce case can be filed in any Virginia Circuit Court in any city or county in Virginia. Now that doesn't necessarily mean that the court has the power to affect all the rights of both the spouses. It's possible that the court might not have the power to affect the rights, say, of a non-resident spouse, as at least that spouse's property interest, the obligation to pay spousal support, equitable distribution, the division of the parties' property and debts. So the marriage itself is considered to be a thing, a res, and all that's required to terminate the marital relationship is what's called in rem jurisdiction. And all that requires is that the party who's bringing the divorce case in Virginia is a bona fide resident and domiciliary of the Commonwealth of Virginia and has been so for at least 6 months prior to the filing of the divorce. It's possible that the parties were married somewhere else, live somewhere else. One of the spouses happens to move to Virginia, and if that person is an actual resident domiciliary, considers Virginia to be their home for the indefinite future and has connections to the state of Virginia, then that person can file for divorce in Virginia and terminate the marital relationship. Now, if that spouse wants to affect the property rights of the other spouse, due process required under our Constitution requires that the court have in personam jurisdiction, personal jurisdiction over that spouse. Now that's easy if the spouse resides in Virginia, both spouses resided here, last cohabited here as husband and wife, and both of them are still in Virginia. The spouse only need get service of process, appropriate service of process on the Virginia resident spouse. Now the problem arises when one of the spouses is not in the Commonwealth of Virginia. Virginia has what's known as a long-arm statute, which allows a Virginia court to exercise jurisdiction, in personam jurisdiction, over a non-resident if that non-resident has certain connections to the state of Virginia. And I've listed 4 of them in connection with family law cases in Virginia. This would be the first step in the process. The second step would be the connections to Virginia would also have to satisfy constitutional due process concerns. So the 4 elements to create a connection with the state of Virginia might be, first of all, that the party who's the non-resident owes support under a contract to a Virginia resident or somebody who's considered a resident who's in the military or in the foreign service by statutes in Virginia. The second base for long-arm jurisdiction would be support is owed, and again in both cases it's support to a spouse or a child. Support is owed to a spouse or a child by a court order rendered in a Virginia court that had personal jurisdiction over the non-resident. That person could be hauled into court or expected to answer a case affecting his or her rights here in Virginia. The third base for long-arm jurisdiction would be that the person fathered or conceived a child in the Commonwealth of Virginia. And the fifth one would be that the non-resident had a matrimonial domicile in Virginia at the time of the separation, or at the time the divorce was filed, or when the cause of action arose. So in any of those three instances, the court could exercise in personam jurisdiction over someone. So that's a brief overview of Virginia, whether Virginia is the appropriate place for someone to file, considering the rights they want to have and how they want to affect the other party's rights. Now, venue is simply a matter of convenience. This is there's preferred venue and venue that's not preferred. If a party files a case in a circuit court, a divorce case in circuit court in a county or city that's not a preferred venue under the statute, the other party could make a motion, object to venue within 21 days after service of the complaint for divorce, the summons, and have the case transferred to the preferred venue. The court, acting on its own, also might transfer the case to a preferred venue when it's filed in a venue that's not a preferred venue. And sometimes this is done for the convenience of the lawyer. The lawyer's office might be in one jurisdiction, in one particular county or city where it's easier for him or her to file a divorce, and sometimes none of the parties has any objection to that, and as long as it's a Virginia Circuit Court, that's fine. It's probably unlikely in that circumstance that a judge would transfer it on their own, although it's possible. Now, the preferred venue in Virginia is the city or county where the husband and wife last cohabited, or it can be the city or county where the defendant resides at the plaintiff's option. So the person who's being served with the divorce case, if the person who's filed the divorce case wishes, they can always file it in that city or county. And finally, if the service of process is by publication, which is a process where a spouse has tried to serve their spouse, they may not know where their spouse is, and they will serve them by publication, advertisement in a newspaper, or posting at the courthouse, which, by the way, may not give them in personam jurisdiction over the person. That type of a divorce case may be filed also where the plaintiff resides. Again, an objection can be made within 21 days, or the judge can, on his own or her own, transfer the case to a preferred venue. So those are your two concerns, jurisdiction and venue. You should consult with your Virginia lawyer to discuss where your divorce case should best be filed.